SJC-11487, Commonwealth v. Marcus Mitchell.
May it please the Court, David Mark for the Commonwealth. This morning, Your Honor, I'm going to waive my rebuttal time. This case presents, in the first instance, a question of the interpretation of the one-party consent exception to the wiretap warrants requirement of a warrant for an interception of a secret interception of a communication. The requirements to meet that, the B4 exception, are that an investigative or law enforcement officer has been given prior authorization to record the conversation by a party to the conversation, and that the recording or transmission is made in the course of the investigation of a designated offense. And of course, that definition is critical too. A designated offense is one of the statutorily listed offenses committed in connection with organized crime.
And I take it that's not an issue in this case?
Correct.
Whether or not this was a designated offense?
Well, so actually that's not correct. As I think about it, my brother has made the argument that the judge below was right for the wrong reason. So I hope actually to address that.
I'm sorry. So the argument is this is not a designated offense? The investigation was not into a designated offense?
So if I understand my brother's argument, the argument is that the investigation of the murder is not
because it's not
sufficiently
connected
related to the organized crime.
It's not connected to organized crime.
So he would say there's a lack of nexus. There's no question. So I've lost you.
I'm sorry. This is a murder investigation, is it not?
This is a murder investigation.
Okay. And
a murder is a designated offense, but it must be committed in connection to organized crime.
Was it raised below? I'm sorry.
Yes, my brother raised that below.
And it was decided below?
It was decided below, correct. That was decided.
That this was an investigation?
Yes, that point was decided by the judge below in favor of the Commonwealth. So, but my brother is here to argue, and I think he's entitled to do so, that the judge below is right for the wrong reason. Certainly the Commonwealth does that.
Can I, maybe interrupting your flow, but if I understand your argument correctly, you say we've met all those, it's a designated offense, it was an investigation, you had the consent of the party, and you had a law enforcement officer involved.
Correct.
All the way along. I'm just, assume for the minute, you put to one side your argument that this really did relate to the murder, that the actual conversation, because your first argument is it doesn't really matter.
That's correct, that it doesn't matter.
So if it didn't relate at all, you would still, your point is it shouldn't be suppressed. We would still have a relevance problem. I mean, we may not be able to introduce it at trial because of relevance questions, right?
That is exactly the Commonwealth's argument. And in fact, it presumably wouldn't come in the murder investigation. This case is before you on the gun case. This has been suppressed in the gun case, which is a separate, it's the same indictment number, but it's a separate indictment.
But
it won't be, it's been severed. It won't be tried with the murder.
Right. But so you're saying whether, again, putting aside whether the conversation did or didn't touch on the murder.
Yes.
If it didn't, you would be happy not to use it in the murder case. It's only about the gun case that is that right?
That's correct.
But the suppression goes to both at the moment.
It does.
Okay.
If I understood your argument correctly in your brief, your point is, I take it, that this conversation focused on the piece of the investigation as to the issue of was there an organization involving illicit activity. You were trying to establish the existence of organized crime.
I'm not sure that
You wouldn't have to have directly implicated the murder in order to have this conversation secretly recorded.
That's correct, Your Honor. In other words, as long as we've met the prior requirements for B4, what happens in that recording isn't suppressible merely by virtue of the fact that it ultimately doesn't touch or reach the murder. So we, as Justice Botsford noted, we do say in addition that it did, but even if it hadn't at all, it had clearly been only about the gun case. It's easy to create a hypothetical. Our informant says, hey, how are you doing? Well, you know, gee, I'm really sorry I left that gun on you, and I have to run now. Click. Okay, so there's nothing now in this alternative hypothetical. There's absolutely nothing about the murder, no allusion to it whatsoever. Our informant didn't even have the chance, perhaps, to ask anything, but certainly didn't ask anything about the murder. In our view, because this was in the course of an investigation of a designated offense, it is permissible then to use that as evidence, albeit not in the murder case. It would come in.
Even though the gun case in and of itself is not a designated offense.
Correct.
Are there any limitations on that principle at all? I mean, what if you think maybe you're not going to get any information about that case you're investigating, but it'd be a really great way to check out all these gangs in a way that you wouldn't ordinarily be able to because you can't connect all the stuff that they're doing to a designated crime. Let's just do this. Are there any limitations?
Yes, but I think those
What are they?
limitations are really built into the in the course of language. So what you're proposing is a hypothetical where this is really pretextual.
Right.
That the designated offense that we are purporting to investigate is in fact not what we're interested in.
Or you are, but you're hoping really to get other things.
Right, or there's something much more interesting that we might be. So
May I ask you this? When you ask for the ability to tape the conversation, isn't it implicit that this conversation will involve the designated offense?
no, that is certainly the judge's view, but that is not the Commonwealth's contention is that it's not necessary to meet the B4 exception that that our informant succeed in either that he do the job we asked him to do, or that he succeed in doing the job, and that is it's not necessary either that he elicit information or indeed that he
Well, wait a minute.
try.
You're saying we're investigating this murder.
Right.
And we want permission to be able to tape this conversation
Yes.
about the murder.
And we are asking you, Mr. Cruz, to ask this
About the
suspect
murder.
about the murder.
Yeah.
And then he goes off and does his own thing. In our view, that's still okay because all the preconditions were met. Our hands are clean. We have set in motion someone we don't entirely control. Mr. Cruz he's a character.
Well, he hijacked the conversation and talked about what he wanted to talk
He did, but the point I wanted to make, though, is that we don't really want to be in a position where we're chargeable with treating him as if he's a police officer. This is a man who, just sort of two data points on Mr. Cruz. This is a guy who apparently was shot in a bar by a man he knew and said he didn't know who did it. That gives you some indication of what he was thinking about how this was going to be resolved. And in an earlier one-party consent interception, he was recruited by the person he was talking to kill a witness to the Pina murder. That fact, the fact that the suspect there, Mr. Fernandez, thought that Cruz was likely to do this, tells you a good deal about what his view, at least, of Mr. Cruz's character. And he knows Mr. Cruz a good deal better than we do. So this is not a police officer or someone we want to treat as if he's a police officer.
But you would, in response to, I think, both Justice Duffley and Chief Justice Island, you would say that at least to get where you got, the trooper who sort of set Cruz in motion had to say, we want you to talk about the murder.
He has to be acting in good faith. He has to
He
set
has
this
to
in
say,
motion.
that's what
He
you
has
are
to say-
supposed to be talking about.
And that was met. The
No,
judge.
I understand that, but I mean,
That's a
he couldn't-
requirement.
He couldn't get this warrant.
Then we're in
and-
trouble in the course of. So,
Okay.
if I may anticipate a hypothetical here.
Okay, but go ahead. I mean, I'm trying to figure out how you define in the course of. Is it that the investigator was acting in good faith with the intent to gather information?
If you like, that this is
So
in
this is so-
pursuit of gathering of evidence for the designated offense under
So
investigation.
that no judge can decide this without the investigating officer being on the witness stand, and he has to determine his credibility with regard to what his intent was with regard to it?
Well, not necessarily, Your Honor. I mean, in this case, we had, so if there had been no blood warrant here, then I think the answer is yes. Once the defendant makes a motion to suppress, I believe it's our obligation to defend what we've done. So I think we'd probably have to, we'd have to present the testimony of the investigating officer to establish his bona fides. But that is established by his conduct up to the time of the intercept, not by looking at what was recovered in the intercept.
So if you had, speaking of hypotheticals, if you're doing a murder investigation and you say, well, there's a key witness who's engaged in a separate prostitution scheme. I think if I can nail him on the prostitution scheme, I can flip him to be a witness in this murder case. That's okay?
I don't know the answer to that. That actually, I wouldn't go that far, but it's an interesting point because I think it could certainly be argued that you're still in pursuit of the murder investigation, that effort
I'm
to...
trying to get a sense as to, I mean, whether or not you're essentially eviscerating the legislative requirement by saying that anything that you think will help you investigate this case is okay as long as you're acting in good faith for that purpose.
I certainly don't want to be in a position to do that, and I don't need it, so I hadn't anticipated the hypothetical, so I'm not, I prefer, let me not go that far.
But what is your narrower formulation?
That the intent of the officer who sets the informant in motion is narrowly to generate information useful to the prosecution of the target offense, rather than, in your hypothetical, to get him in a position where he's now compromised and has to help you. The hypothetical I was going to propose was, how does the situation change if rather than using an informant, the officer himself is operating undercover? Now it seems to me the obligation is a little narrower for the officer to we still have to make the same showing. And I would say that in that instance, it's still the case that the bona fides of the B4 exception is established sort of at the moment that the recording begins. So even with an officer, it's possible to imagine a situation where the officer says, you know, he's sort of warming up his target, and in the course of that, never having gotten to the target offense, the target reveals something that's independently a crime, something like what happened here, but inadvertent, and then hangs up. And it is our view that nonetheless there, where the officer was acting in, you know, his intention was to gain information about the crime under investigation, that would be okay. It's not necessary, even in that situation, for him actually to have succeeded in gathering information about the matter under investigation. And it's not even necessary for it to be okay that he make a kind of overt attempt in the course of the conversation. It's only necessary that it have been legitimate that he was in pursuit of that kind of information when he made the call. And then, so in that instance, I think it would perhaps be fair for the defendant to start by pointing to the call as evidence that, in fact, this was not legit, it was not in pursuit of, which I think gets back to Justice Duffley's hypothetical. But again, the question is always whether it's, you know, in the course of, and that's the key determination that needs to be made under B4. I've left myself exactly a minute and a half to address the defendant's second argument. I wonder if I can just do that for 90 seconds. The defendant essentially makes 2 points in his argument that the judge below was too quick to give us the organized crime requirement for B4 and the nexus to organized crime. So in brief, our point is, if you look at the blood warrant affidavit, it provides a good deal of information establishing, first of all, that we're dealing with an ongoing retail drug enterprise in the city of Taunton.
This is Team Supreme?
Team Supreme. I think Team Supreme already takes us out of the Tavares universe. As far as the nexus is concerned, there's a good deal of, remember, we're still in a reasonable suspicion universe. The link to the providing of illegal goods and services here would be, you have a long established history of these of Montero and his group being a threat to the physical safety of Team Supreme. You've got, in response to what is perceived as a threat, Mitchell gets a gun from Jeffries. There is a parley that goes badly, where we have a silent movie of this in the affidavit, but we have a meeting between Jeffries and
Cruz?
sorry, not Cruz, Jeffries and Montero that goes badly. Montero knocks Jeffries down. After that, but that meeting seems to involve seconds. It seems like it's a sort of a meeting of enemies to work something out. It goes badly. Sometime later, Cruz is shot. And then after that, there's the attempt on Montero's life that ends up killing Pina. You look at all of those facts, and I think what emerges from that is the nexus between Team Supreme and the murder of Troy Pina, the attempted murder of Montero, is simply that as an organization, they recognized a threat to their existence from an implacable enemy. And that essentially, in an effort to protect their own physical safety, they were furthering the retail effort of the for-profit effort of their ongoing drug organization. Thank you.
Thank you, counsel.
May it please the court, Richard Klebanner for the defendant. If I might just briefly address that organized crime question. I think if we even look at the underlying factual findings of the motion judge, he essentially agrees with what the Commonwealth just said, which is this is a beef involving the physical safety of rivals of some sort. And the shooting, to the extent that, and the shooting was an attempt to protect a member of this group from attacks from this other group. But there's no connection made between that and the alleged drug enterprise. The underlying factual findings of the motion judge speak of bad blood between the groups and physical attacks between them, but nowhere does he draw a connection between that and the drug enterprise. But to get to another point.
But isn't, before you leave that point, I mean, isn't there a view that if you're involved in the sale of drugs, the appearance of weakness is bad for business because you're always vulnerable to an opposing group to take advantage of you since you're selling drugs and you have turf and you risk losing that turf if you appear weak?
As a very general matter, that's probably true, Your Honor. But in this case, there's simply no connection made. If that were the standard, then any physical attack between two criminal groups would be part of organized crime.
But only if the person who did it is involved in the sale of narcotics, which not every gang is.
No, though they're involved in a number of other they're usually involved in at least one of the designated in some type of criminal business, Your Honor. But in this case, Your Honor, there's simply no connection. I suppose if there had been evidence of some sort that this was done for that purpose, it'd be a different case. But there's simply not in this case. One thing the Commonwealth said confuses me a little bit. I believe the Assistant District Attorney just said that the Commonwealth is glad not to use this evidence in the murder case on relevancy grounds. That's not the position they've taken in the trial court. In fact,
But I think I was asking him, in fairness, put aside their connection, the second transcript and the argument that actually it does weave into the murder. I think he was answering that.
I may have misunderstood then, Your Honor, because in the trial court, the Commonwealth certainly taken the position that it intends to that it believes it can use this in the murder case. And I think it's clear that this motion to suppress, I don't understand the argument that this motion to suppress only relates to the gun case. The motion to suppress was brought after the cases that the gun case was severed from the murder and shooting cases. The motion to suppress was afterwards. Everyone at trial at the motion level treated this as involving the murder, including the trial judge, who said, you can't use this, I'm suppressing this in the murder case. So I think that's really what's at issue here. As a general matter, Your Honor, the purpose of the statute is to protect our communications from interception and disclosure, except in this very limited circumstance where they involve organized crime, committing certain offenses. The best way to do that is to look at the statement itself, what actually, the evidence that was elicited. And clearly in this case, as the motion judge found, it had nothing to do with the murder. The Commonwealth believes otherwise, but there's certainly no clear error on the part of the motion judge on that question. Commonwealth has a number of theories as to why this was really, they were really talking about the murder, but they're purely speculative.
Well, is it your view that the investigator was not acting in good faith here when he initiated the telephone call? That he was not seeking to gather information to further the murder investigation?
I believe he was, Your Honor. However, he also knew that his informant, who he was using as his agent in the investigation, intended to talk about something else. That was made very clear to him. And he told the informant, do what you need to do, implicitly, explicitly giving him permission to discuss matters other than the murder.
No, I understood that, though, is in an effort to get the conversation to the murder, do what you have to do.
That was probably what the state trooper wanted.
It was like he wasn't going to cut him off from doing what he needed in order to be able to segue into the murder.
That's correct, Your Honor. But the question becomes, once we get other evidence, once we get evidence of non-designated offenses, whether those should be able to be disclosed and used at trial. And I think the best way to protect the purpose of the statute is not to allow those in. Because once we do, we open a loophole in the statute where a conversation may start out about one thing and then get into other things which are meant to be protected communications under the anti-wiretapping statute.
So it sounds as if one huge difference between you and Mr. Marks is Mr. Marks says the key focus is the intent of the persons when they initiate the call. And you say, no, you need to listen to the call and determine what actually happened.
Exactly, Your Honor.
Would you have a different answer if, let's say, that it was not ambiguous at all, that both offenses were discussed separately? I mean, different parts of the conversation. Your point is that you just can't, you could use it as much as you want, the relevant part for the murder, but you cannot use it in this to be separately tried gun case. Is that what you're saying?
Well, you could not use you cannot use the part of the conversation which is evidence of a non-designated offense, in this case, the gun case.
Even though, I mean, in this hypothetical, the conversation treats both offenses. Motion to suppress is denied because the murder, the designated offense, is clearly covered and the judge finds everything else to be okay. And the blood warrant goes by the by because it actually isn't in a home or whatever. Anyway, so no motion to suppress. But would you, if you were the defense counsel, you would come in and say, well, you should give a partial motion to suppress because you should not be able to use it no matter how good it is for the murder. You cannot use it in this to be separately tried offense. Is that what you're saying?
No, I don't think so, Your Honor.
Okay.
What I'm saying is that there would be a motion to suppress. It would be
Right.
to suppress the part of the communications which are not within the exception.
Yeah, that's what I'm, okay, so it would be, so just suppress the gun part of the conversation.
Yes, Your Honor, because that is the part that's intended to be protected by the statute. It's not, this part of the conversation that does not involve a designated offense and organized crime is meant to be protected by the statute. The statute is very explicit on what is, the statute is very explicit on where the exception is. and it's a
But what
limited
if, what if the evidence, what if the conversation was essential to establish organized crime, to establish a, for instance, a conspiracy to commit murder, an agreement in the motivation for the murder?
Well, if it is evidence of the murder, Your Honor, then
it's admissible.
Then it's admissible. I won't get into the conspiracy question because I really haven't thought about that.
So you're not interested in you would say that concepts like in getting a warrant to search a home and then plain view just don't apply here because it's statutory and there's a limitation that's really intended to be narrower than the idea. Just the designated crime, the target crime, is really the only thing you can get at, even if something comes up inadvertently, even if you see or hear something inadvertently without looking for it.
That's one point I would make, Your Honor, that plain view is not a statutory exception.
Right.
But I think we can go beyond that. Even if we were to apply plain view requires inadvertence. There's no inadvertence here where the informant told the state trooper, I'm going to talk about guns. I'm going to talk about the gun. It's hardly inadvertent. Secondly, plain view applies when one is in a place one is supposed to be, where one is permitted to be, and one sees something that can then be seized. Here, what was the very thing seized, to use that analogy, is a conversation which is protected under the wiretapping statute.
But isn't the wiretap statute really designed to prevent secret recordings, right?
Secret recordings and disclosure, Your Honor.
Okay, well, but it's really about the start is the secret recordings, right?
Well, it's actually an exception. It doesn't require a recording, but
I guess my point is if on the facts it is permissible to allow this one-party consent conversation to happen because the criteria for allowing that have been met in a hypothetical, and the conversation has a whole lot about the murder, and that's fine. You're saying you've got to pick and choose that you can only, that everything that isn't related to the murder gets suppressed.
yes, Your Honor, I would, because
And
that
why
part-
is that furthering because you say that's furthering the statutory goal of no disclosure?
Well, it furthers that, but it also furthers the statutory goal of of keeping our communications private unless they fall within the exception.
Well, so if they engaged in a conversation about the target offense, about the murder, and then the person who the informant was talking to said, look, I want to talk about something else. I want to talk about that other crime that we committed 5 years ago. Boy, we really fixed that guy good. That can't be admitted?
It cannot be
I mean,
admitted
because
as-
there's no effort to, or there's no intent to circumvent the purpose of the statute. This is something that came up spontaneously.
I would say it cannot be admitted, Your Honor, unless it falls within statutory exception, which it may or may not, but unless it does so, it is protected by the statute.
So you're really focusing on the protection of this speech. You're not really focusing, you conceded a point earlier, on how broad this loophole can go and how it might be used to further illegitimately or as a subterfuge to gain information otherwise inaccessible. That's not your concern?
Well, certainly there's a danger there if the loophole is opened, how it may be used, but I am not relying upon the good faith or the intent, the original intent of the law enforcement official.
Now, let's assume you prevail here and the tape recording does not come in. Is it your view that Cruz can also not testify to his memory of what occurred?
I believe under the statute he can, Your Honor, though I'm not completely confident in my answer.
So the issue is simply the admissibility of the tape recording itself,
Yes.
not of the telephone call.
I believe that's correct, Your Honor.
Well, that's even true. I mean, the blood case itself made that point, right? I mean, it would be fine for
For
the,
the actual person involved in the conversation to testify, yes, Your Honor, it's true on the blood. There are no further questions, Your Honor. I'll rest on my brief.
Thank you. We'll take our morning recess.
All right.